It is my great pleasure to welcome today's seminar or colloquium speakers here for the Sierra Seminar Series. We have with us today a panel that will be speaking to bad bodies, borders, and unbelonging, conversations about medical inadmissibility in honor of next week's World AIDS Day. Prior to beginning, I would like us to take a moment to reflect on the land from which we are joining this particular colloquium today. York University recognizes that many Indigenous nations have long-standing relationships with the territories upon which York University campuses are located that precede the establishment of York University. We acknowledge our presence on the traditional territory of many Indigenous nations. This area known as Tkaronto has been caretaken by the Anishinaabe Nation, the Haudenosaunee Confederacy, and the Huron-Wendat, and is now home to many First Nations, Inuit, and Métis communities. We also acknowledge the current treaty holders, the Mississaugas of the Credit First Nation, and recognize that this territory is subject to the Dish with One Spoon Wampum Belt Covenant, which is an agreement to peaceably share and care for the Great Lakes region. Please take a moment to reflect on the land from which you are joining and acknowledge the original caretakers where appropriate. With no further ado, I would like to turn this over to our moderator for today, and Professor Laura Bisaillon, who's from the University of Toronto. Welcome, and thank you again for joining us.
Good afternoon, everybody, and thank you for the warm welcome. And thank you to the CRS for hosting this. My panelists and I are thrilled to have this opportunity, so thank you for the logistical support, as well to Michelle Millard. Did you know that if the late Stephen Hawking had wanted to settle in Canada, he would likely have been denied? This is because he was physically disabled. As a group, Canadians know little about the inner workings of their immigration system, despite that it's been a core institution that's been formalized since the 19th century. The Canadian immigration system includes a medical program regulated by the Immigration and Refugee Protection Act. A medical system embedded within an immigration system is uncommon globally. Doctors, lawyers, civil servants, and others enact the immigration system through their professional work practices that coordinate with one another inside and outside Canada. Federal immigration law is currently organized to exclude people with chronic illness, disability, and genetic otherness from permanently settling in Canada on health grounds, with some exceptions. Such people are conflated with notions of risk, bad bodies that are informed by 19th century public health forms of reasoning. The legal term for this process and phenomena is medical inadmissibility. Medical inadmissibility is achieved by making an applicant for permanent residency legally ineligible under what is called the excessive demand clause. And since the logic of exclusion is not self-evident, it must be opened up for inquiry. A first prima facie assumption is that such barriers to immigration are undesirable. A second assumption is that Canada must understand and then resolve harms created by its immigration laws, policies, and institutional practices. A last assumption is that scholarship starting within the relevancies of people with firsthand experience with medical inadmissibility is valuable and desirable for its transformative promise. Today we are 5 presenters. We have Anne-Rachelle Boulanger, we have Valentina Capurri, we have Cliff Pereira, Felipe Montoya, and myself, Laura Bisaillon. We will be exploring issues related to medical inadmissibility using various forms of evidence, including lived, scholarly, and legal, which then makes it possible for us to converse with our audience, you convened today, about your own knowledge, thoughts, and experiences, as well as the discoveries that you make through our panel. The 5 of us argue that the medical inadmissibility regime and its implications matter to all of us. lest we are comfortable with supporting, however unwittingly, harms that stem from the social organization of the immigration medical system as it exists currently. Our aims for today are twofold. Firstly, to inform and educate our audience about how a key Canadian institution's medical program works and to demystify it along the way by looking at the system from the inside out. Secondly, to support and give resonance to a new legal challenge to the medical inadmissibility provision, which is an ongoing effort that you will learn about today in the details that are going to be provided by Anne-Rachelle. And lastly, we would like to acknowledge the support from our host, the Center for Refugee Studies at York University, and acknowledge that this event is co-sponsored with the Canadian Studies Network and the HIV Legal Network. So the format of today's 90-minute panel is going to be as follows. 30 minutes for personal testimony, 10 minutes for social science and humanities evidence, 15 minutes for immigration law in practice and action, 30 minutes for conversations with the audience, and then a 5-minute request of invitation for you as the audience as a conclusion. So now we will move into the first of three testimonials, and the first one will be offered by Valentina Capurri.
Hello, everyone. Thanks for coming. My name is Valentina Capurri. I'm going to provide my testimony here, and then I'm going to talk a little bit about the work that I've done, academically on the subject. So I came to Canada in 2001. I was an international student at York University. I was in the Department of Geography there. And not even a year after I arrived, I was diagnosed with multiple sclerosis. When I decided to apply for permanent residence to Canada, I really knew very little about this provision in the Immigration Act that prevents people with medical conditions or disabilities from being accepted into the country. So it was pretty shocking to me, the whole process was extremely stressful and laborious to go through, and definitely left a lifelong impact on my perception of this country, its immigration system, that it was very different from what I started with when I initially arrived. Because of this, because of my experiences, I also decided to use this as a opportunity for me to know more about these kind of policies, and that's the reason why subsequently, when I finished my master and I started my doctorate, also at York University, but in the Department of History, I decided to do my dissertation on this particular act, this particular article in the Immigration Act, because it's something that I don't think it's very well known even among scholars that have that are, whose field of study is immigration. I think it's something that has been silent, so not discussed that much. So that's the reason why my study was focusing on this. And my study is pretty long, in temporally. So I study from 1902 all the way to 2002, so 100 years time. And I try to understand what is the political discourse that was developed around the inadmissibility of persons with disabilities or with medical conditions into the country. So my study, that is this one, not good enough for Canada, is divided into three major areas. So the first part, I look at the discourse that took place among politicians on the subject. The second part, I look at the discourse that developed in the written media. Particularly, I focus on two major newspapers in Canada, the Globe and Mail and the Toronto Star. And then like the last part, it's a more recent period of time from the 80s to 2002. I focus mostly on the legal perceptions and like the impact of, for better word, the lack of a significant impact on the charter on this kind of provision. Uh, so overall, like if I was supposed to give a general perceptions of what I found out throughout my study, is that this discrimination against like a specific group of people, again, those with a medical condition or a disability, is something that has been inherent in the Immigration Act from the very, very beginning. So Canada obviously became a country in 1867, and the first Immigration Act like was formulated the following years in 68. And this like already there was a mention in the legislation about preventing the entrance of people that were considered at the time to be faulty. So in the first few decades, what I found out by looking at like the discussion among politicians and how things were discussing like the media was that overall there was a feeling of being uncomfortable with people that were considered faulty, and the biggest fear was that they could potentially compromise the genetic makeup of the country. So there was this general opposition to the arrival of certain individuals because they were like considered like bringing a disease with them, contaminating unhealthy population. And instead, Canada was just forming during that period, and they wanted to like be created as a healthy body. The second phase that I was able, because whereas the provision remains pretty much always in place throughout the years, what I notice is that the justification for it tends to change. So how in the political discourse, like the rationale for maintaining this policy tends to be different. And so at one point, like in I would say, roughly in the period that coincide with the years like of the Great Depression and the decades following soon after, the main concern becomes not so much that persons with disabilities or chronic diseases that were coming to Canada could really contaminate the genetic makeup of the country, but becomes the issue of unemployability. So because the economy was struggling, so the general argument is these people are useless. They're not productive. They're not going to work. So they're not going to contribute to like the well-being of the country. So there is a lot of emphasis during those years that is put exactly on this, the fact that like Canada coming to the country was a privilege, and therefore like Canada was selectively trying to attract people who could contribute to the economic well-being of the country. Persons with disabilities were not included in this group. Things change further, like in the years following that, like when, like all of a sudden, like it's become untenable, like throughout the 60s, like it became untenable, this kind of like stand, even considering the fact that during like the World War II, when many like healthy men had been sent to fight like overseas, persons with disabilities were employed and were used like across the country to provide further support to the economy. So that argument that they were unemployable started to falter. And in the 60s, though, like the rationale got shift once again and became, well, it's not that these people are unemployed, but because now we have a free healthcare system, then like these people are like draining our resources because they are like bringing with them, they represent an excessive economic burden. And that kind of argumentation has remained to these very days. I do remember very clearly, like the first time that I naively applied to immigrate to Canada, and I did receive like a warning letter from the immigration office warning me that they were going to reject my application because I have been deemed an excessive burden on like Canada Health and Social Services. That kind of like was really a shock in the sense that like it might not seem a shock if you hear it like that, but if you receive a piece of mail where it's written in clear character that you are considered a burden for someone, it kind of impacts you. Like at least it impacted me quite a bit, and like has really affected like my general perceptions of my relations with others. Like I try like as much as possible, for example, never to take day off when I'm sick, because like I know like rationally, because I study this, I do know that like it's unfair, that I shouldn't feel like that, but there's so much an impact. There is something behind my back that say, oh, no, 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 you cannot be considered a burden. Like, so do an additional step, like push it a little more, because you don't want to be considered a burden. And so I assume this is like a similar reaction that many other people would have received. Now, having said that, eventually I was allowed to stay in the country, but like even that is kind of problematic in itself, because I did reapply. Like I was rejected as an independent immigrant because of my multiple sclerosis. I did subsequently reapply as a spouse of a Canadian citizen. My husband is Canadian, and like the provision in the Immigration Act that was passed in 2002, like the IRPA, was like exactly to allow for children and spouses of Canadian citizens to be able to be accepted into the country. So this is the way I was finally able to get kind of in. But even that, I think, has left some kind of a bittersweet taste in my mouth, because it is tough to know that like you are accepted not because of what you can bring or you can contribute to the country, but just because accidentally you happen to be married to like someone that is a Canadian citizen. And so I think that's in itself is also like a problematic situation. Now, like my analysis go from like throughout all the 20th centuries. Later on, Laura would pick up from here, because her study follow thematically, chronologically, I mean. And so she will give you a better sense of how the Immigration Act has evolved, like the policy in the 21st century. For now, I think I'll leave it here. Like, thank you so much for your attention, and I'm looking for your questions at the end. And I pass it to Cliff, I believe, or to Felipe. Laura, can you?
So, excuse me.
I think it's
Do I
to
pass?
Philippe.
Oh,
It's
Felipe.
Yeah.
Okay,
Felipe.
sorry.
It's Felipe. Yes.
Okay, thank you. Thank you, Valentina, for your testimony, and thank you all for participating and joining us in this webinar. So I'm Felipe Montoya, better known as the father of Nico, who was deemed inadmissible because he has Down syndrome. So I was hired by York University. I'm Costa Rican. I was hired by York University in 2012, and I went with all my family to Canada. And 1 year later, in 2013, we began our paperwork to request permanent residency, which was a requirement for me to continue working at the university. And so we went about our business like all immigrants. And one of the first things we had to do was do a medical exam to see if we were healthy. We all took the exam, the medical exam, and we all came out healthy. The only problem was that my son is visibly Down syndrome. His genetic makeup, he wears on his skin. It's easy to identify him. His genetic makeup is different. Even though he came out healthy, suddenly he was burdened with further exams to see if in fact he was healthy. So Nicolas, my son, had to undergo exams, thyroid exams, x-rays, et cetera, et cetera. Finally, this went on for a couple of years, actually, and finally ended up going to a psychologist to see, because he was physically healthy, and so the psychologist had to determine if he was intellectually disabled. Of course, having Down syndrome is almost always equated with some kind of cognitive disability. So yes, he was declared cognitively mildly disabled. And so that went to immigration, and because of Nico having Down syndrome, he was declared inadmissible for permanent residency in Canada. This, in a country like Canada that is known worldwide as open and open to immigrants, and also respectful of it has in its charter laws that prohibit discrimination based on disability. So this ruling, and in fact this whole procedure of the medical examination and then burdening my son with further examinations because he's disabled, already from the very start was a process, a discriminatory process. So this went on, and this really bothered us because it was wrong. It went against. It was illegal in our minds, my family. It went against the Canadian Charter of Rights and Freedoms. It went against conventions, United Nations conventions that Canada had signed, in terms of the defense of the rights of people with disabilities. And so it already seemed to be somewhat dark, this ruling. Especially when I started to look at the Immigration Refugee Protection Act, the IRPA, and looked at Division 4, which talked about all of the reasons that inadmissibility for permanent residency exist. And they include people are deemed inadmissible to Canada for security reasons if they've been terrorists, for human rights violations if they've been war criminals, for organized crime if they've trafficked, involved in human trafficking. And then finally, for health, being a danger to public health or a danger to public safety. And finally, for excessive demand, which is what Valentina mentioned. So costing the state an excessive amount of money. So Nicolas, completely healthy, my son Nico, completely healthy, was not deemed an excessive demand in health terms. But once that didn't kick in, then finally he was deemed inadmissible to Canada for excessive demand in social services. And what were those social services? Well, he was going to public school, and he was in the special classroom with other people with cognitive disabilities. So that was the excessive cost that Nico represented to Canada. When I challenged this, asking the school how much more did Nico cost Canada for being in that classroom? And they said, no, nothing. There's no excessive cost for your son to be in here because the teachers are here, the students are here. There's not really any cost related to that. But Immigration Canada deemed that he was inadmissible because of this excessive cost. And those services, those social services that are used to calculate inadmissibility are precisely those that help people with disabilities to become part of society. And these social services are those that Canada is proud of having, so that all of the citizens can become can become integrated into society. So it's kind of tautological, or this circular reasoning that you are inadmissible for the social services that you require, and it's precisely only those social services that people with disabilities require that are used to calculate inadmissibility. So in the end, Nico was deemed inadmissible, and the family along with Nico as well. I don't know how much time I have left. Laura, do you know?
3 minutes.
Okay, great. So, what to do? We were deemed inadmissible. We had to leave Canada. But I, I, I promised my son that we wouldn't go without a fight, and not necessarily to be able to remain in Canada, but because this discrimination against boys or children with Down syndrome seemed to be beyond what Canada should accept as normal. So we took this to the media. A commentator that many of you probably know of, Rick Mercer, found it astonishing that, and he gave his rant. He said, "How is it possible that Canada doesn't accept this boy because he has Down syndrome?" Anyway, that received a number of likes, and finally, we took this to the radio, to the TV, to newspapers, and it reached the ears of the minister and an immigration minister. We went to his office in Ottawa and presented our case that this was against the charter, Canadian Charter of Rights and Freedoms, that it reduced the value of people to this monetary amount instead of recognizing the value of Nico in himself, what he could bring to society, as well as the value of his mother, his sister, and myself as productive members of society in whatever we do, as well as in paying taxes. So we were paying our taxes, and the services that we expect to receive from the taxes we pay, those were considered an excessive amount, despite the fact that it was negligible according to the school Nico went to. So there were a lot of contradictions. And when I hear Valentina speak about people not good enough for Canada, that's what I really sensed during this whole process. There was no economic reasons that were valid. There was no medical reasons, because Down syndrome is not a medical condition. So in the end, it was that Nico was genetically contaminating the country. That's what we felt. He wasn't good enough for the country. In the end, similar to Valentina, we are permanent residents of Canada, even though we're not living there at the moment. But the minister intervened on humanitarian and compassionate grounds to give us permanent residency. That is fine and good, but it does not resolve the problem of this being a law that continues to be present today. It continues to have this discriminatory nature to it, and it isn't good for Canada, not only economically, politically, but even spiritually. I think it's a blemish on Canada's good name. So I think I'll leave it there.
Thank you, Felipe. We'll now hear from Cliff.
Hi, I'm Cliff Pereira. I used to work in the UK in HIV services for a good 10 years. I also departed from that field and slowly segued into historical geography, and was involved in setting up exhibitions across the world, starting off in the UK, but expanding. Um, I was diagnosed in 1998 with HIV, and I met my partner, now my husband, in 2002. He was offered a job. He was headhunted from a London company and offered a job in Vancouver. He went over for 2 interviews, during which he raised the issue of me joining him as a person with HIV. My husband is HIV negative and I'm HIV positive, but he raised this issue because the idea was, could we live as a couple in Canada? And he was assured by his company that this was not an issue. And I think that reflects the ignorance around this whole system. That even companies recruiting from overseas are unaware of the facts. Anyway, he got the job, and because we were assured this wasn't a problem, I followed him to Canada and we got married in Vancouver. The company started to urge us to apply for permanent residency because they said we can't keep extending your work permit. We need to have some sort of permanent residency in place so that we can rely that you're not just going to disappear tomorrow. And during this process, I started looking for work, and not just in Canada, but overseas. And basically, as we applied for the permanent residency, I ended up being a curator for the National Museum of Qatar, which is quite some way from Canada. It was a very good job and one of my top curatorial positions. But as the process went on, we found ourselves under a lot of pressure because we had to go for all these tests over and over again. And I jokingly said to my husband, I said, I almost wish that one of these tests turned out positive, because how many STD tests can you keep repeating month after month and coming up with a negative reply to them? I mean, what is it that these people are particularly after? And honestly, the two of us had at least 4 tests in a matter of 5 months, which is quite ridiculous. During this process, I was still getting my HIV drugs from the UK. But as the process continued, the government came back to us saying, you are although you're healthy, you're expected to cause excessive demand. That was the terminology used on Canada. Now, I had actually looked at the prices of the drugs I was on in the UK with my clinic in the UK, and the prices in the UK did not match the pricing that Canada Immigration was producing. So there was something not quite right here. But to be reduced to the point where you are not an individual, but, as Valentina said, you become a burden and you're reduced to a price tag. I found this very difficult to deal with. And both of us ended up thinking, how can we possibly work with this? I needed to travel overseas for my work, and my husband needed to travel to Asia for his work. And it got to the point where we said to his company, well, you invited us here. What do you propose to do about this? And they said, well, we're trying our best. We've got somebody in Ottawa trying to do things, etc., etc. What we suggest is that you take a job in either Singapore or Hong Kong. This is what was said to my husband. Now, Singapore has no LGBTQ rights whatsoever, and Hong Kong at the time would not recognize our marriage, which meant that we could go to Hong Kong, but I would have to leave every 6 months because that was the term of my tourist visa. So we've gone from being in a stable place in the UK to an unstable place in Canada. and then to Hong Kong, where basically I couldn't even get a cell phone because I didn't have an identity card. And you know what that does to you is it takes away your self of assurance, your self of identity, because suddenly you're nobody in the country. You know, can you imagine functioning in a place like Hong Kong without a cell phone? And everywhere I go, I had to walk with my passport because I didn't have an identity card. Now, it got very, very difficult, but we put up with it. And it was almost 9 months later, after we'd got a 3-year contract on our rental in Hong Kong, etc., that Canada said, "Oh, you've now got your permanent residency." But the whole process was so traumatic that we basically turned around and said, "No, thank you. We'd rather go through the hardship we've got here because this hardship was on the cards. Hong Kong never hid its recognition or lack of recognition for us. This was already there. We knew this. Whereas in Canada, we felt we'd been given a completely false impression of what Canada was about. And it turned out to be for us very devastating in so many ways. Now, some years later, Hong Kong did recognize our marriage because it was procured overseas. And so that's the situation we are now in. So, you know, looking back at this, actually, it's not something that I think was new in many ways in retrospect, because after coming to Canada, I was asked to work on a Canadian project. Excuse me. It was called, it was a film called Thrown into Canada, funded by the Aga Khan Trust, and it was about the Uganda Asians who were expelled by Idi Amin in 1972, and a bunch of them arrived in Canada. And while doing the research on that, one of the things that I was told by the people who didn't get into Canada was that they were told in Kampala and in the refugee camps in London that if any of them had had an STD in the past, they were eligible for immigration as refugees to Canada. And I realized that this issue has been a constant, very much as Valentina said, but that it's changed at times to exclude certain people in different ways. And I've kind of come to the point now that I think I don't think I could have been happy in Canada after going through that whole process, because it shattered my dream of Canada. But it also has led me to realize that the picture Canada posts to the rest of the world is not the reality of Canada today. And I think I think there's a sense of loneliness in this process, because most of the people that you're talking to in Canada have never experienced it, even though it's a country of immigrants, and cannot actually relate to how bad it is. But I did tell a First Nations friend of mine about it. And it's something that's stuck in my mind ever since. And he said to me, "I'm the only Canadian that has the right to say whether you can come to Canada or not." And I thought that was an incredibly strong statement that literally had me in tears. Short and sweet. I don't have much more to say. Thank you.
Thank you so much, Cliff. Right, so now what I will turn to speaking to you about in 10 minutes is results from the social sciences and the humanities. 。 So as we've heard, implicit within the sharings of Valentina, Felipe, and Cliff is the acknowledgement that a central part of an immigration application as a social process is a medical examination. So this is a mandatory step that occurs for the most part outside of Canada. The immigration system is a large bureaucracy that is textually mediated, and that begins in the case of medical decision making with the medical file. So all that then happens is triggered by the work of general practitioners who are charting and composing a medical file. In 2019, there were 925,000 medical examinations done, which was lower than it had been in the past because it was years of COVID or on the becoming COVID. And these medical examinations are done by contract physicians who are inside and outside of Canada. Of that 925,000, 650,000 were done outside of Canada. The stakes of negative medical assessment are high. People can be screened out of being eligible for immigrating to Canada, depending on the results of the diagnostic tests that are done on them, and then later stage legal, medical, and administrative decisions made about them by state workers, by lawyers, and by doctors. And in 2022, an idea that I get from Valentina to show the book cover. In 2022, I published the book entitled Screening Out, HIV Screening and the Canadian Immigration Experience. This was based on my long-time ethnography of the Canadian immigration system, where I was interested in understanding it. I was interested in understanding it from the perspective of people such as Valentina, Cliff, or Felipe, those who are eligible to be excluded. So in the book is a sequence of events in the application process of a sub-Saharan African woman in her interactions with an immigration doctor. And the book is an institutional ethnography of the Canadian immigration process from the perspective of people to whom the exclusionary set of policies is directed. And I wrote this book in a particular style because I want people to read it and be able to read it, to appreciate the scholarship and what is revealed in the pages. I've written it in a story form. It's a narrative-driven, political, economic, institutional analysis that is in this form of dialogue between an immigrant applicant named Martha and an immigration doctor who's working for the immigration department. And so through the exchanges in this genre of writing, we learn about the events in Martha's diagnosis with HIV and what that gives rise to. So I show how things come to be problematic, the social organization of the problems that Cliff experienced, that Valentina experienced, that Felipe and his family experienced, the answers to that. How was that produced? In their interactions with social services, public health, schools, clinics, legal institutions, housing, the justice system, disability organizations, community level service providers inside and outside of Canada. And the argument that I'm able to offer based on empirical evidence is that medical examination and mandatory HIV screening triggers institutional practices that are highly problematic. Highly problematic not only for would-be immigrants, refugees, and refugee applicants, but for those civil servants, for those doctors and there's lawyers, among others, whose professional work tethers them to the immigration system. And I arrived at being able to produce a corrective to state claims about itself, the ideological claims about the functioning of medical examination and HIV testing, and offered ideas for correctives at particular places where things need to change. And we'll hear about those particular places when we hear from Anne-Rachelle in terms of legal analysis and a charter challenge that's underway. So let me explain briefly what I mean by highly problematic. I've made this claim. What are my findings? Well, three. Problematic in terms of the institutional logic, the organization of the system. So the immigration system, as we've heard, is a disableist regime, which means that things are set up to discredit and to exclude particular bodies, so that bodies are actively devalued and acted upon in particular ways through particular institutional practices. For example, within what we heard from Valentina, she speaks about the feeling of hearing of herself as a burdensome person, a bittersweet acceptance into the country. The Immigration Act and in its language gets under the skin and inside the head of people, and providing them particularly a particular set of relevancies to then begin thinking about themselves and acting on themselves, if you will. All people, doctors, lawyers, civil servants, are directed by what the Immigration and Refugee Protection Act tells them to think about people with chronic illness, different genetic compositions, and disabilities. So they are instructed within particular discursive ideas to then go out and do their work. Second is the level of institutional scrutiny. What we heard in Felipe's testimony, for example, how their son Nico was acted upon again and again and again with different and deeply probing sorts of tests, in the story of Cliff as well. So a diagnosis of any sort or a medical decision of any sort gives rise to specific forms of attention on particular bodies that are othered and considered bad, which then in turn give rise to particular sets of institutional interactions for the would-be applicants. The last point I'll make is around the practice of institutional medicine or organizational medicine, immigration medicine, as I've called it in prior writing. There are serious inadequacies with how forms of patient care are carried out within the medical examination, and that has consequences well beyond the medical examination itself, as we heard in the stories of Valentina, of Felipe, and of Cliff. What we see is doctors as contractors or contractors as doctors are having to practice in the interests of the state, which are footed or predicated within relations of exclusion. So in this context of the medical examination, they are asked to be working not in therapeutic ways or within relations of therapeutic care. They're actually asked to become civil servants and to be looking for reasons to exclude. So this disturbs taken for granted notions about physician responsibility toward patients. So this type of doctoring is at odds with ethical and professional principles of medical practice. So in this instance, the doctor is a fact finder, clinical reason displaced, obligation of form filling. Each of these three findings present avenues for legal reform. Valentina experiences life with multiple sclerosis, Felipe and his family with Downs, Cliff with HIV infection. What we are doing through our panel is talking back to those medical categories that would and have historically otherwise sorted people with MS and Downs and HIV into 3 different baskets. What we're doing today is bringing these biosocial identities and medical categories together to show that despite differences in medical conditions, the 3 families that we've heard from today had similar tensions, contradictions, paradox within their immigration experience and indeed their outcome. I'll conclude there, and then I will call on Anne-Rachelle Boulanger.
Thank you, Laura. So I'm going to walk us through the legal underpinnings of medical inadmissibility. My fellow speakers have provided a lot of really useful context, but I want to make sure we're all on the same page when we get to discussing the charter challenge against medical inadmissibility. So let me just share my screen. Okay. So medical inadmissibility. I think by now we all have an understanding that this is the legal basis the government uses to say that someone can't enter Canada or can't stay in Canada for health-related reasons. Felipe laid out the 3 types of medical inadmissibility earlier on, but I'll remind you, it's either someone is deemed to be a danger to the public health, to public safety, or an excessive demand on health or social services. We are focusing on excessive demand because that tends to be the one that's used most often. And as I have on the screen here, every year between 1,000, 1,500 people have their applications rejected on the basis of medical inadmissibility. Most of those are excessive demand rejections. Ooh. Okay, so how exactly does excessive demand work? Basically, every year, the government sets a cost threshold, and it calculates this cost threshold as 3 times the average a Canadian's average healthcare costs. So in 2025, it's about $27,000 a year. This is, and we'll talk about this in a little bit, this cost threshold used to be just 1 time a Canadian's average healthcare costs. So it's increased substantially, whereas people living with HIV used to be excluded disproportionately by the provision. Today, most won't be excluded as most medications fall below the cost threshold. But of course, if people have multiple conditions or the particular type of medication is more expensive, they can still be refused. Okay, so let's keep digging into it. How does excessive demand work? So by now we've heard about the immigration medical exam. This is a required medical exam for certain visa applications. It's required for all permanent residence applications. The doctors that provide the exams are Immigration Canada approved doctors all over the world. You can see on the screen that hundreds of thousands, if not millions of people go through these exams every year. There are several issues with these exams. We've heard of many of them already, but there's mandatory HIV testing that don't meet our public health guidelines in terms of consent. People don't always get referrals to adequate treatment or support. Confidentiality is often breached. People aren't told what they're being tested for, et cetera. And of note, Canada is one of the few countries that still has mandatory HIV testing as part of their immigration medical exams. So in 2017, the House of Commons Standing Committee undertook a study of the excessive demand regime. And this came at a time where there was a lot of public scrutiny around the provision. There were a lot of high-profile cases, a lot of cases in the media that were garnering attention. And I personally believe this is what sort of pushed this study. And you can see some of the headlines from the day, including one having to do with Felipe, who was very active in that fight to have the discriminatory nature of this regime recognized. I've also included on the screen, outlined in pink, the government's attempts to justify the provision at the time. So saying that the screening program took a risk-based approach that balanced immigration facilitation with the protection of health and social services. Despite the government's attempts to justify the regime, the standing committee found no, this provision is discriminatory, and it recommended that the Canadian government repeal it completely, so no more excessive demand. Following this finding, the Minister of Immigration actually accepted that, okay, this provision is a problem and promised to repeal it. However, he said, in the meantime, while we figure out how to get rid of this provision, we're going to make a few changes. So that's when they tripled the cost threshold. That's why it's higher today. They also adjusted the definition of social services. So we're now at a point where far fewer people are being denied, but we still have this incredibly harmful law in place. So I have on the screen some of the stats that we got here from Immigration Canada, where they confirmed that 85% of people who would have been approved under the old regime had now been accepted. So yay, lower numbers, but we still have the same discriminatory structure. And I think this tripling of the threshold has allowed the government to continue to perpetuate this regime with far less attention on itself. So let's now move on to the Charter Challenge. So this Charter Challenge, it stems from one individual who we call RA to protect his anonymity. He is an international student. He's living with HIV. And when he applied to renew his student visa, it was denied on the basis that he was expected to pose an excessive demand. The decision was very obviously unreasonable. His first visa had been approved, even though they knew about his HIV status. It was just a bad decision. We, however, took this opportunity to not only challenge the renewal, but to challenge the entire legal framework. So we brought a constitutional challenge on the basis of Section 15 of our charter. And this is our equality rights. This is our protection against discrimination. So I'll now walk you through how we make that charter argument. Step one, we have to demonstrate that the law creates a distinction on a protected ground. So the charter recognizes disability as a protected ground, so a characteristic that can't be used to discriminate against someone. And disability is understood in the legal sense to encompass chronic health conditions as well. So for our purposes, that's useful. It allows us to show the broad harms of the provision beyond a strict interpretation of disability. So we argue that, of course, this law creates a distinction based on disability. It only applies to people who could potentially pose an excessive demand. So it only applies to people who have health conditions, medical conditions, or their family members. Now, the government historically has argued that it's not discriminatory, it's just cost-based. Our response to that is it's just because you don't call it disability doesn't mean that it's not discriminatory. So indirect discrimination where the only people being targeted are folks with health conditions or disabilities, is still discrimination. The second step is we have to show that the law that we're challenging imposes a burden and denies benefits to people with disabilities in a way that exacerbates historical disadvantage. So we've heard about a lot of the harms of this law already. Here's what we chose to focus on. So, of course, if you are found to be in excessive demand, or as Valentina said, she got a warning letter. So that's your opportunity to fight back against the government, try to explain to them that you're not in excessive demand. That usually requires getting a lawyer. It involves a lot of resources and a lot of time. If you're processed under the excessive demand regime, that will lengthen the processing of your application by months, if not years, even if you are accepted. The excessive demand regime treats you as though you are just costs. It doesn't recognize the values that you bring, be it economic, social, cultural, you name it. It perpetuates very stigmatizing views of disabilities as, their burdens on society. It also perpetuates stigmatizing views of migrants as just being here to, drain our resources. And of course, it leads to folks being forced to abandon opportunities, plans, if they don't have the time or resources to challenge or appeal government excessive demand decisions. So one point that I think is important to focus in on is this idea that it only looks at costs and it doesn't look at benefits. There might be an urge or a sort of instinct to say, let's look at the benefits that people bring. But we warn against this for a couple of reasons. First, the government is unable to really determine with any accuracy the cost that someone will be on our health or social services. But more importantly, it's just so dehumanizing. It's adding to this calculation of whether or not someone is worthy. And yeah, it's basically saying, okay, you have a health condition, well, prove to us that you're worth it. So we really caution against that as being a solution to this, this regime. Now, if we are able to make out the case that the law is discriminatory, the government then has an opportunity to save the law by saying that it's justified. The government hasn't shown us their arguments yet. They've been trying to get this case kicked out on procedural grounds, but based on what they've said in the past, our guess is that they're going to really stress the fact that we need this law in order to protect our healthcare, our public healthcare, to save costs. Fortunately, we have some strong case law that confirms that cost savings aren't justification for discrimination. There's no end to how many discriminatory laws you could justify if you were just going to base this off costs. So that helps us. Additionally, and we found from the government's own records that they've admitted that they don't have the capacity to track how much they're saving with this law. But they say their best guess is that it's 0.1% of provincial and territorial healthcare budgets. That's not significant, first off. And second, this number is from 2017. So this number is before the tripling of the threshold. That means that any cost savings that we had in 2017 are definitely lower today. So we already had an uncertain and significant number. We don't know for sure, but I think we can make an educated guess that cost savings are not substantial here and certainly can't justify the discrimination that we're perpetuating with this law. So we are calling on the government to revoke the excessive demand regime inside, outside court. I think personally, I believe educating more folks about this, getting the word out about this is one of the most effective things that we can do. I do believe that, folks like Felipe who are going to the media helped really push forward the law and make these gradual little changes. And so we need to keep that energy up. So I've included 2 websites here. First is the Legal Network's website. We're working on a page dedicated to this regime. Unfortunately, it's not ready yet, but check it out. But more importantly, I've included here a website put together by Laura that includes a ton of resources on medical inadmissibility, including links to Felipe's website for all the advocacy he did around his son. I've also included our emails here for folks who want to reach out with ideas, questions, personal experience, etc. Okay, so I'll stop sharing my screen and we can open it up to questions. And if folks don't have questions, we have a little exercise planned.